I think it's important to understand the current state of the law, and I think the gentleman from Shenandoah got it. I think he got it right. The way it currently stands right now is that the way it currently stands right now, some judges, before the Supreme Court issued this decision, some thought they had the inherent authority to continue a charge for dismissal, some didn't. Okay? And obviously, different people had different views on that. It depended on your jurisdiction, depended on your judge, it depended on a lot of things. And the Supreme Court came down with this case, which decided it, which called it one way. They called it a way that some people don't like. And the Supreme Court basically said that our judges, the people that we appoint, have the inherent authority to continue a charge, to dismiss it, to take it under advisement as part of their inherent authority as judges of this Commonwealth. Now, we in this body elect, a couple hundred judges every year. And at least I know in my jurisdiction, we vet them very carefully. We look at their qualifications, we look at their character, we look at their experience, and we decide whether or not we believe that these people possess the proper character, authority, knowledge, temperament, etc., to pass judgment on people. I mean, these judges, folks, make some of the toughest decisions that anyone has to make. They have to make decisions. They can't kick the ball. They have to break up families. They put people in jail. They sentence people to death. And in rendering these kinds of decisions, it's imperative that judges have discretion. Practicing law, I see people at their worst every day. I've seen situations that I never thought could have possibly occurred. I've seen people charged with things for reasons I never could have imagined. I've seen people put in situations I never would have imagined. And it's because of that, you have to have discretion built into the system to be able to deal with all the possible scenarios which can be presented. I mean, none of us are that omniscient. None of us are wise enough sitting here in this chair to be able to dream up all the different reasons why somebody could come before a judge and be presented with a criminal charge. I don't think anybody here is that smart. Now, what this is really about is about limiting judicial discretion. That's what this is focused on. I don't think there's any disagreement. That's what this is really focused at. And it's part of a trend. There's been a trend in this Commonwealth nationwide towards mandatory minimum sentences. There's been a trend towards judging people by machine. We do it with breath machines. We do it with radar guns. The latest invention is red light cameras. We do it with, we passed a bill last year about toll booths, I think. Now, if you think that you have the confidence, if you believe in that, if you believe in trial, if you just want to have somebody up there who's just rubber stamping things, who's just processing sentencing formulas, somebody who's just going through a routine instead of somebody who we trust to exercise their discretion about what they should do when confronted with a situation, if you want to just have an automaton, then this is your bill. If you believe in the quality of the people that we put on the bench every year to pass judgment on our constituents, then you vote against this bill. To me, it's that simple. And I would ask that the bill not be engrossed or passed on the third reading. Thank you, Mr. Speaker.